calificas para ser legal. ¿Quieres saber? Solo llama al abogado Andrés Mejer.
Mi nombre es Andrés Mejer, yo sé que no se nota, pero soy hispano. Nací en Santiago, Chile. De vez en cuando alguien ríe cuando lo digo. Nací en Chile, mi madre de Chile, mi padre de Argentina. Y mi familia venimos aquí en los 80. La gran diferencia entre ustedes o mis hijos es, bueno, en mi año, en el 86 la ley cambió y nos dio una oportunidad para recibir la residencia. Hubo actualmente amnistía. Entramos en el 81, nos dieron 6 meses y nos quedamos 30 años. Entonces, estábamos ilegales por casi 10 años. Pero eso fue la última vez que hubo esa oportunidad para aplicar para algo solo por estar aquí. 5 años, aplicas, recibes. Hoy no hay eso. Entonces, pero sí hay unos 9 caminos principales para conseguir estatus legal. Lo que vamos a hacer hoy es hablar sobre algunos de ellos que nuestra audiencia en Facebook ha preguntado. Nos dieron las preguntas, entonces lo vamos a hacer para ustedes.
My husband, 2 sons, and I entered the country illegally. Once in the U.S., my husband abandoned us, leaving me alone to raise my 2 sons. Do my children qualify for legal status?
So, the question asked, mom and 2 kids come over here, father abandons them, what could you do? So, there's nothing that indicates what mom's possibilities are. However, the children, since they're minors, they qualify for something called special immigrant juvenile. The idea behind it is the kids can't be sent back to their country because they're being sent back to their parents' homes, and it's their parents that abuse, abandon, or mistreat them, or one of the parents. Could be neither, could be both. So 5 basic requirements: under 21, single, meaning not married, dependent on somebody. For this example, mom is applying for custody. It doesn't have to be mom. It could be a friend, could be a cousin, could be a relative, could be the courts, or I guess here it's PCPMP, could be a guardian. Has to be, and they have to have been abused, or in this case abandoned, by one or both of the parents, and it's not in their best interest to go back to their country. It's a 3-step process. First is a trial in front of a family court judge who makes those 5 findings. Then they apply for immigration. Immigration recognizes the order. They wait for a visa, and then the children will get their green card. Now, the downside is they'll never be able to apply for their parents. The idea is to, I guess, to prevent fraud. They don't want a situation where dad hits mom, mom comes with the kids get the green card, apply for mom, and then mom reunites with dad, and all of a sudden the whole family gets it. So it's not fair, it's not just, but they just cut it off, and children will never be able to apply for their parents.
I was born in El Salvador, and I am in the U.S. with TPS. My son has DACA, and my wife is a legal resident. What can I do to attain legal status?
So the question is asking, if someone has TPS, which is temporary protective status, how can they achieve legal status, particularly in today's time when the Trump administration is trying to eliminate TPS? So the example that was provided, the spouse, the wife is a green card holder, lawful permanent resident. If she applies for citizenship, she becomes what's called an immediate relative. Now, why is that important? Because the moment that a relationship is approved between husband and wife, there's a visa immediately available. Secondly, in a family-based petition, it's a 2-step process. The first is you're going to document the relationship. Who's applying for me being the immigrant? Is it my spouse? Is it my parent? Is it my child? How do I prove it? Well, my child is the birth certificate. My parent, their birth certificate or mine, depending on who's applying for whom. And what's their status? Well, where were they born? Or did they naturalize? So that's a relatively easy process to prove that. The moment that's approved, we then go to the change of status. That either happens in the U.S. or outside of the U.S. In order for it to occur here, inside the United States, we need a legal entry and we need an immediate relative. Wife becomes a U.S. citizen, we have immediate relative, but we don't have legal entry. TPS provides it's called advanced parole in English. Really, it's a travel permit. You have to apply to say, listen, for the following reasons I need to travel to my country. It gets approved, you leave, and then come back. Most people who have TPS today didn't enter legally. They didn't overstay a visa. If they did, they don't need this process. The majority of people did not. They came here, and at some point they were able to apply and receive TPS. So with legal entry, and then spouse who's a U.S. citizen, now you take something that's temporary and you make it permanent.
I have a 21-year-old daughter born in the U.S. She just enlisted in the Army. Would this help me attain legal status?
Parole in place is very similar to DACA. DACA is deferred action for childhood arrivals. So deferred action at its core is protection from deportation and employment authorization. There's a variety of different categories that are in these groups of individuals that can file for it. Parole in place is one group. DACA is a separate group. The Trump administration is trying to eliminate DACA. Last week, November 12th, there was an oral argument in front of the Supreme Court on whether he can eliminate DACA or not. Parole in place is the same as DACA, but it's just a different group of people. The idea behind it is, if you're giving your service to your country, if you're in the military, you shouldn't have to worry that while you're risking your life, your parents or your loved ones will be deported. So you apply for this because you're either in the service or honorably discharged, and it's usually your parents, or it can be your siblings, but it's usually your parents, will then get employment authorization and protection from deportation. Now, why is this important? In the prior example, when we talked about the man who had TPS and the wife who was a lawful permanent resident, we said, listen, with TPS, you can get a travel permit, advanced parole. You can leave the U.S. and come back in to get legal entry. With legal entry and an immediate relative, like a wife of a U.S. citizen, you can go from temporary protected status to lawful permanent status, which is permanent. So parole in place acts very similar. Once you apply and you're admitted into the United States. Even though you didn't leave, you get the equivalent of lawful admission. So, 25-year-old daughter who's a U.S. citizen in the military, the moment you have legal entry, she applies to you, and within a year, you're a lawful permanent resident. So it overcomes a lot of things, parole in place, but not everything. Multiple entries is a disqualifying factor. Certain crimes are a disqualifying factor, but it's favored very heavily because we want to protect our military members, and we want people to apply to the military. So it's weighed very much in favor. Now, it doesn't help everybody. I have a client who entered the United States in '95, left in 2001 when her father passed away, then came back to the United States, was caught at the border, was fingerprinted, lied about her name, was sent back, then entered the United States illegally, I guess successfully. 20 years later, son's in the Marines, applies for her, she gets parole in place. Son then applies for her green card. She goes to the interview and they ask her how many times she comes to the United States. She said once. I said, are you sure? I said yes. They pulled out a document showing her prior entry with a different name. They caught her lying. She was disqualified from her green card. She could still apply and receive parole in place. It's not easy when you now lie to the government, but it's still possible. So not everybody can be qualified for the green card, but they may be able to qualify for parole in place.
I entered the U.S. through the border 5 years ago. I am presently in an abusive relationship that I want to end. He is an American citizen. Can I attain legal status, and would I need to stay in this relationship until I am approved?
U Visa and VAWA. We're talking about an abusive relationship. Do I need to stay in that relationship? So it really depends. The answer is always no. You don't stay in the relationship. But whether I qualify for a benefit depends. Well, if I'm the immigrant and my spouse is the abuser, let's say she's a U.S. citizen, are we married? If we are, I may have VAWA as an option. VAWA is violence against women's rights. It's not limited to women, that's just the name that they gave it. It can be also men. In a VAWA scenario, it's a family-based petition. The difference is I'm doing it by myself. It's a self-petition. So normally, my spouse is filing for me. I shouldn't have to stay in an abusive relationship only to achieve a legal benefit. So here, I'm applying for myself without any information, well, without informing my spouse. I don't have to stay in that relationship, but I have to prove I entered into the relationship with the best of intentions. They weren't just a friend, they were a loved one. I didn't pay her to do it. We did this out of love, but all of a sudden, life changes after marriage. I was married 14 years ago, and life is very different. but the point of the matter is, it has to be a marriage, and it has to be somebody who's a U.S. citizen or lawful permanent resident. In any family-based petition, I need to prove that that relationship is legitimate. On top of that, I have to prove that I suffered extreme cruelty. Now, it could be that I wasn't aware my spouse was schizophrenic or bipolar, and when she takes medicine, doesn't take medicine, she acts in weird ways. Maybe she was ashamed and I didn't realize it until we moved in together. Or I didn't know that she was an alcoholic or she abused drugs. So something changed, and all of a sudden life ain't pretty. And I should not be forced to stay in that relationship. But the example that was provided, it's not clear whether they're married or not. So if my significant other is a U.S. citizen but we're not married, I can't file VAWA. VAWA, the benefit is I go directly to my green card. It also forgives entry into the United States if I enter illegally. It forgives certain crimes because I'm the victim here. So the burden of proof is higher, but if so, the moment I'm approved, I can apply for government benefits, which normally I wouldn't be able to get for 5 to 10 years. VAWA, if I'm successful, I get my green card, and there's a waiver built in. But what happens if I'm not married, or if my significant other is not a U.S. citizen or green card holder? Well, then I might have to apply for U Visa. That might be my only option. So what's a U Visa? The idea of the U Visa is to help law enforcement take criminals off the street. So I must have actually reported something to the police. In a VAWA scenario, it doesn't matter if I never call the police. I just have to prove that I suffered extreme cruelty. In a U Visa, if I didn't call the police, I don't have a case. Now, if I'm successful, I get U Visa status. I can have that I get it for 4 years. After having it for 3 years, I can then apply for my green card. So I will get my green card, but it will be 7 to 8 years down the road. Whereas VAWA, the moment it's approved, I'm a lawful permanent resident. So U Visa has 6 requirements. 1, victim of a qualifying crime. 2, I had information about, I reported that crime to the police. 3, I helped the investigation or the prosecution of that crime. 4, I suffered emotional or physical harm. 5, I'm a good person. In other words, I'm not a criminal. And 6, I need a law enforcement certification, a sworn affidavit from either the judge, the prosecutor, or the police. Basically, it says I was helpful, I was a victim of qualifying crime, and I was helpful. So VAWA, I don't need to report it to the police, and I don't need that affidavit. But in the U Visa context, I do. So in some cases, that's harder. But U Visa is broader. It can help more people because it's not marriage-based, not necessarily. Domestic violence is the most common one, but it could be any violent crime, any of 23 to be specific.
10 years ago, I entered the country through the border. I have a 5-year-old son with cancer receiving treatment. What happens if I get deported? I can't leave my son alone.
The example talked about a woman who came here 10 years ago and has a 5-year-old child with cancer. So I assume the 5-year-old child is a U.S. citizen because she's been here 10 years. And she hasn't left, otherwise she would have been able to come back. So there is something in Spanish, in slang, they call it the 10-year law. There really isn't one. It's an oversimplification of a very complicated process. But the idea is, if I'm in removal, if the government's trying to deport me, if I show certain circumstances, I will get a green card. I'll become a lawful permanent resident. But people think, oh, I'm here 10 years, it's automatic. It's not. I have to be in removal proceedings, which means if the government doesn't know where I am today, I have to tell them, hey, I'm over here, please deport me, please put me in proceedings because I have a reason to be protected. So it is a trial, and at the end of that trial, either the judge will give me my green card or will deport me. It's one or the other, there's nothing in between. But it's a very long process. If today I'm not in removal proceedings, the process might take 5 to 7 years until I get to that final stage. And first I have to start with an asylum application, where I'm saying, I'm afraid to go back for me or for my son, for a variety of reasons. One of them may be inadequate medical care, or, you know, as a single parent, I may have difficulty giving my son adequate care, particularly if I'm working or I may give me a job because I have a sick child. So you need to make a reasonable argument. But the bottom line is asylum, this, you know, I need to file within a year of entering the country or a year of changed conditions, and that didn't happen. So asylum will likely get denied unless I'm successful and I convince them the law should be changed. But that's usually up in the appellate. Now, in the moment, I'm denied, I'm now in removal proceedings. Now I can file for this process. But there are 4 main requirements. 1, I've been here 10 years. 2, I'm a good moral person. 3, I've not been convicted of a disqualifying crime. And 4, extreme and unusual hardship to, in this case, the child, who's a U.S. citizen. So here in the U.S., he gets insurance, he gets treatment, and he has an opportunity for a better life. In our home countries, that may or may not be the case. So I need to show, in my country, what will be the level of care that he will have? Is he even a citizen there? Will he have medical treatment? Now, there's a big difference if I'm from El Salvador or if I'm from Spain. The level of care is different. What happens if I'm a citizen of both countries? Now, I would need to show that he will not have an opportunity for that same level of care in either country. Long and short of it is, she has a path to get her green card. It's a long one. They only give $4,000 a year, and it will take a number of years. There are risks because it's a trial, and we don't know who the judge is going to be, and we don't know what the law is going to be 6, 7 years in the future. But for some people, it's the best path they have. It's usually the last one we recommend because it takes a long time and it is the most expensive. So if someone has a U Visa or a family-based petition or a VAWA, we usually recommend almost anything else because they're all quicker and they're usually more controlled. I can't control what a judge decides. I can control what USCIS sees, and to some extent I can predict what they're going to decide.